If you're a veteran with back pain, knee issues, or any joint condition, and you take medication and or use braces to get through the day, you need to hear this. A brand new court case called Ingram v. Collins might change how the VA rates your disability. And guess what? It's for the better. Okay? Now, the VA is implementing Ingram v. Collins by requiring examiners to disregard the beneficial effects of medication when evaluating certain musculoskeletal disabilities and report the condition's severity as if medication were not being used. This is because the relevant diagnostic codes and regulations do not explicitly contemplate the use of medication. In practice, this leads to a reevaluation of the disability to determine its baseline severity, which may require remanding the cases to the board for addendum medical opinions. Now, I know that's a lot of information to break down. That's what we're going to do here today. So I'm going to break down the top 5 ways the Ingram v. Collins case could change your VA rating. I'm Mr. X. I'm the guy behind the guy, giving you all the information you want to know and need to know about the VA claims process. This is the VA top 5. All right. The VA just began implementing Ingram v. Collins. Okay. Today's video is going to be a little bit different, as you can tell already. I'm so pumped up to get this information out to you because this really could make a huge difference in your life. Okay, I'm going to try not to ramble. I'm not going to try to go on and on. But we need to understand the details and the background of this case to determine how it could affect you. And then I'll get to the top 5. So here's the background and the key holdings from the Ingram v. Collins case, okay? So the veteran, Mr. Carlton Ingram, he had a service-connected back and left ankle disability, and his claim for higher evaluations were denied. Now, the veteran took medication, over-the-counter and prescription medication for pain in his ankle and his back, which improved his symptoms and condition. The VA examiner noted that the medication used, but also did not assess how the disability would function without the medication. So, for example, what was the worst case scenario or the unmedicated scenario? Now, the court reaffirmed the rule from the Jones v. Shinseki argument. That's when the relevant diagnostic code for a disability does not contemplate the use of medication. So, for example, if the rating criteria doesn't incorporate improvement by medications, then the VA cannot rely on the beneficial effects of medication to assign a lower disability rating. Oftentimes, now, where this shows up when evaluating disabilities is the range of motion measurements. And how this may affect you is this. And I'm going to speak of the back right now. So the forward flexion of the back, okay, 90 degrees is considered normal or the max. Okay, so below 90, the thresholds are 90, 60, and 30. So if your flexion is 85 or 70, you're going to be rated at the 10%, especially if there's just pain. Anything below 60, you're going to get a 20% rating just based on flexion alone. And anything at 30 or less is going to go up to 40% or less. Now, where this may affect you, and it could affect each and every one of you very differently. So on your most recent evaluation or examination, the DBQ, okay, when they did those flexion ratings, if you were at 65, and which, should warrant a 10% evaluation. If you're at 65 and you take medications on the daily to get through the day, that 65 is based on the use of medication. So if the examiner now has to consider your symptoms without the medication, that might go to 55 or 50, which may bump you up to the 20% evaluation already. And that's just one evaluation. That's just your back. The VA has to consider this rule, the Ingram v. Collins, with every musculoskeletal condition. So in this case, because the VA rating criteria for the back and ankle disabilities didn't explicitly include medication use, the board and the VA should have discounted the beneficial effect of the medication and evaluated the disability as if the medication effect were not present or minimal. The board did not do that, so the court set aside or remanded the decision for further development. The court also stressed that even though there are special musculoskeletal regulations under 38 CFR 4.40 and 4.45, which require evaluating functional loss during flare-ups or on the use, they do not negate the Jones rule when medication is involved, and the diagnostic code doesn't account for medication. Now, why is this significant? Okay, so many veterans with joint back conditions rely on medications, pain meds, anti-inflammatory meds, braces, and the result, their functioning looks better because they're braced up and drugged up and medicated. But what would those conditions look like without those aids? Well, Ingram says that if the rating criteria doesn't explicitly consider those, for example, the medications or the braces, the VA cannot give credit for improvement caused by those medications when assigning a rating. In simpler terms, you shouldn't be penalized or get a lower rating simply because you take medication that helps your condition. It underscores that examiners and evaluators must consider the unmedicated flare-up or worst-case scenario of functioning. Now, if they only look at the medicated or controlled state, now this is where they could get into an error. Okay, this decision, the ruling, provides a concrete tool for identifying a legal error in VA decisions. If you see a musculoskeletal disability, so if in your musculoskeletal rating, if you used medication and the examiner or the board did not account for the effect of those medications or described how you function on the day-to-day without those medications, then you may have a basis for an appeal right now. Okay? This doesn't just affect one person or tens or hundreds. This is thousands to tens of thousands of you that have knee evaluations if you're rated for your feet, for your back, ankles, wrists, shoulders, neck, even if it's TMJ, temporal mandibular joint disorder, even in your jaw. This could affect that rating there as well. Okay, this ruling is huge. It's gigantic. And the combined effect of all of your disabilities perhaps going up, or at least multiple of them, this may be the huge difference you need to get in that 100 club. All right. I know it's a lot of information to digest. Now I'm going to break it down into the top 5 things to take from that. Okay. Now, depending on how the VA really implements all of Ingram v. Collins, this may require more and additional videos in the future, or if they pivot to adjust how they rate some of these conditions based on Ingram v. Collins, then some of this may change in the future. So keep that in mind. Okay. Now, number 5 thing. The VA can't lower your rating just because medications help. Okay, that's the number 5 thing to take from this. So, if the diagnostic code for your condition doesn't mention medication, then the VA has to rate you as if you weren't taking it. Now, how does that translate? So, if your pain medication make you look okay on paper, but without them you can barely move, which I know is a great many of you, then the VA must consider the unmedicated state. And that's huge for many of you who are on painkillers, muscle relaxers, or on anti-inflammatories. The number 4 way that the Ingram v. Collins case could change your VA rating is examiners must evaluate or consider you as unmedicated. So in this court case, the veteran's exam showed he was doing all right, but only because he was taking medication. The examiner never said how bad it would be without them. So the court said that that's an error. And if your exam didn't ask or describe what your pain and movement are like off of the medication, you might have grounds for an appeal. Now, translate that to, you, the veteran, listening on your couch, on your phone in the bathroom. Okay. If you're service connected for a musculoskeletal disability, and I would say if your overall is at 80 or 90%, and you're getting really close to that 100 club, then getting your condition reevaluated when the examiner has to consider what your day-to-day looks like without medication, this may put you in that 100 club. All right, the number 3 way that this helps you. Flare-ups and real-life function matter. As you know, I've been talking about this for quite a long time. Talking about describing your symptoms. Okay? If you've been one of my regular subs for quite some time, you know I've been preaching about talk about the details, talk about the real-life function and effect of your disability. Now, this court case, it reaffirmed that the VA ratings must look at functional loss, not just the range of motion numbers, must consider the bigger picture. So if your pain skyrockets after use, during flare-ups, or when you skip your meds, then that needs to be a part of the rating. If your exam only measured you on a good day and while medicated, well, that's not an accurate picture of your disability, right? That may be what you have to do on the day-to-day, get medicated up, but that's not the real version of where you're at. All right, number 2, this rule applies to all joint conditions. Now, just start from the top of your body on down. If you have TMJ or temporomandibular joint disorder in your jaw, it affects that. It applies if you have neck condition, shoulders, elbows, wrists, fingers, your low back condition, leading into your hips, knees, ankles, feet. It affects it all. Okay? If your diagnostic code doesn't talk about medication, Ingram says that you can't credit, the VA can't credit you for improvement caused by those medications. That means if you take meds, use a brace, rely on physical therapy to walk or move, then your actual unassisted function is what matters in your rating. Now, let me translate this to you. If you are prescribed medication, use joint or use braces or prescribed braces, okay, then I would strongly consider putting in for a claim, because this could put you up. This could bump you. This could increase you to the next level. Okay? Only good things happen from this court case. All right. And the number 1 way that this could affect or change your rating is you might qualify for a higher rating or remand. Now, I haven't hidden my feelings about where I think this is going. For most of you that are service connected for a musculoskeletal condition, if you're borderline in between the lower end and the mid tier, or if you're close to that next tier of rating, then I think this could absolutely put you over the top. Now, not knowing the specifics of each of your files, not knowing what goes into or what went into that rating, I wouldn't know for certain. Okay? But based on this information that came out, I'm guessing that a lot of yours are going to go up. Okay? So check your recent rating decisions. If in those decisions, if it didn't mention medication or the effects thereof, okay, then that might be your signal to challenge it, because you might be entitled to that higher rating. I know the VA right now, they are in the early stages of implementing this. So, for example, if you've already submitted a claim for a musculoskeletal condition, knee, back, ankle, whatever, and you already had an exam, but you haven't received that rating decision yet, then if the examiner did not provide this Ingram v. Collins information, then the VA should be sending that back for consideration and clarification. I know they're already doing that, or should be doing that right now. So if you get a decision, I would say from today moving forward for a knee, back, or ankle, and they haven't mentioned anything about Ingram v. Collins or the medicated effects of that, then I would appeal that right away, because that's a signal that, guess what? Someone screwed up. Someone did it wrong. All right, wrapping it up here. I know I've probably rambled a little bit. I apologize for that. That's not in my nature, but I'm pumped. I want to get this information out to you. That way you can go through your ratings and determine if this really does affect you. This Ingram v. Collins decision is a huge win for veterans dealing with chronic pain and joint conditions, because the VA can't judge your disability only by how you look on meds. If your claim involves pain, medication, braces, or flare-ups, this could be your key to a fair rating. All right? Now do me a favor, okay? If you watch this video, if you got something out of it, if you think that this Ingram v. Collins is going to affect you, or has affected you, or will affect you in the future, you owe me a thumbs up. Okay? This could change your rating completely. Drop a comment. Okay? If there's something that I missed, if there's something you would like me to highlight, drop me a comment. Okay? I'm probably going to be doing a few more videos about this in the future as more information comes out. So please remember to subscribe for more no fluff VA claim tips, broken down with a little humor, some honesty. I'm Mr. X. Thanks for being with me. This is VA Top 5.